The offense of imprisonment for life, that is rest of the natural life of person, is another form of meting out effectively the death penalty, since there is no remission for this punishment. Once a court passes a sentence for the entire natural life, it has effectively condemned the prisoner to the death penalty. It takes away any hope of release for good behavior, repentance, rehabilitation, reformation, age, health, etc. And by increasing the number of sections to which these egregious forms of punishment is made applicable, we are widening the net instead of the reformist direction of the Supreme Court in not awarding these punishments except in extremely rare situations. Commutation. The philosophy of commutation is grounded in the belief that public welfare will be better served by inflicting less than what the judgment fixed, recognizing the value of mercy in governance. Every civilized country recognizes this and has therefore provided for such power to be exercised as an act of grace and humanity in proper cases. Without such a power of clemency, a country would be most imperfect and deficient in its political morality. The 1973 Code allowed a broad discretion to commute any sentence to any lesser sentence so that you can reduce a life imprisonment to even a shorter term or even to fine. But the new legislation, the BNSS, restricts this discretion. It introduces what I call a staircase system, allowing only a one-step down commutation, that is from death penalty to life imprisonment and no further, or from life imprisonment to no less than 7 years, and so on and so forth as provided in the section. This restrictive approach takes away the discretion of the state to show its mercy, grace, or humanity in a given case. Let's take another aspect of this legislation. One of the other concepts introduced by the BNSS, which potentially takes away liberty, is the ability to conduct a trial and render a conviction against an accused and sentence him in absentia. Previously, the code only provided for trials in absentia to protect the evidence of various witnesses until the accused was found and brought before the court. Now, Section 356 provides for a complete trial, a judgment of conviction, including the imposition of punishment in the absence of an accused. This raises significant due process concerns. To obviate the obvious natural justice issues, it provides for a legal aid lawyer to such an accused. But in a criminal trial, where witnesses must be cross-examined, it is impossible for a lawyer to represent the accused without any communications with him or instructions from the client.